So, okay, you have different levels of courts. So you have superior courts and you have inferior courts. A superior court is actually a, excuse me, is actually a court of record. Okay. All other courts are inferior courts. So, what if a court is proceeding according to the four requirements? Then it's a court of record. Okay. The four requirements are: keeps a record of proceeding, has the power to fine for or imprison for contempt, proceeding according to common law, and the tribunal, the one who does the judging, is independent of the magistrate who's conducting the proceedings. So that's a court of record. That's a superior court. Superior courts are constitutionally recognized in many states. Court of record is actually good in any state, but some of them actually admit it. So an inferior court is any court that breaks one of those rules. So normally it's extremely easy to know if you are in an inferior court. Just look at the judge. If he's making a decision, you're in an inferior court. He's not allowed to make decisions other than ministerial ones, and only minor ministerial ones. So the court is, it's very important that you have your court, when you're running your own case, you want it to be a superior court. Or now for example, in California, all the courts are called superior courts, but that's not good enough. They actually have to act like a superior court, otherwise they are inferior courts. Okay? Go to any court, like I said, if he's making decisions, you know it's an inferior court. Now, what's the difference between the two? The important difference. Well, right here it says it. It says, and I guess I'll expand it to make it easy to read. There are nice large letters. Okay. The only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of a superior court, and there is no presumption in favor of the court if it is an inferior court. Court makes a judgment. Is it believable? Well, if everybody goes along, I guess it must have been. But technically, you cannot assume it was a valid judgment. So what you can do, here's an interesting, this raises an interesting situation. You get a traffic ticket. You go to court. You don't agree. Judge says you're wrong anyway. Okay, but it's an inferior court. He's making the decisions. So after you get all through, now you turn around and you sue him. Start a brand new case all over again. And this applies to any inferior court. So because why? Their judgments do not carry any presumption of validity. Okay?
So for this red light thing, I can take.
Well, if you got a photo ticket, you know, where the camera catches you in an intersection or whatever, then there's a real question of constitutionality, because the camera, although they say it's a witness, you cannot cross-examine the witness, therefore it's unconstitutional. Okay? Let's see, we have here, what I just read from you came out of a case called Ex parte Kearney. And the cite's 55 Cal 212. And it makes a point here that note, however, that in California, Superior Court is the name of a particular court. But when a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, it is a court of inferior or limited jurisdiction for the time being. So, traffic court. It's limited to judging traffic matters, right? Therefore, it's an inferior court. By statute, it's going along with just statutes which limit it. You cannot bring in other factors. Okay? Probate court. That is an inferior court. Why? Because it's limited in what it can consider. Unlawful detainer courts. Those are inferior courts. You cannot go into an inferior court and say, wait a minute, I own the property. That has nothing to do with the question. Okay? They can still kick you out of your own house that you own based on the evidence given to it, but the evidence is limited because it cannot consider the fact that you're an owner. That's outside its realm. And by the way, I saw a case recently where there was an unlawful detainer action against the person, and he owned the property. So what he did a quiet title action in a separate court process. And he did a quiet title. A quiet title is a suit against the world, saying basically that if anybody thinks he owns the property, better step forward now, or else you lose your right to the property. That's a quiet title. So he did a quiet title, and then after the quiet title, consolidated the case, the quiet title case, and the unlawful detainer case. That stopped the unlawful detainer case because obviously if you own the property, how can you be thrown out of it, right? So that effectively put a stop to the unlawful detainer. It can get more complicated than that, but in the big picture, that's what it is. So any court that's going according to statute, and that is defining its limitation, it's an inferior court. A court of record has unlimited jurisdiction. Okay? So when they run by statutes, the statutes limit it. So anyway, that's a important thing to understand. Back down again.
And is it tax court or superior court?
As it turns out, it is. And here's why, if I can get to it.
What was that question again?
Is it tax court or superior?
Is the tax court an inferior court or a superior court? And I'm telling you, it's a superior court. But they don't use that name for it. It's in the federal system, and so the only term that they can really use, or the only term they do use, is court of record. So I'll have to. Okay. Tax court. Here's the direct answer to your question. We'll expand it. '26 United States Code, Section 7441. There is hereby established under Article 1 of the Constitution of the United States a court of record to be known as the United States Tax Court. The members of the tax court shall be the chief judge and the judges of the tax court. So you notice that in these laws or rules or whatever you want to call them, when they mention judges, they don't ever mention what their duties are. Just like here, it's got to have a judge, but what's his job? Well, his job is based on tradition. So, in a court of record, the judge cannot make a decision. Now, what the IRS typically does is they send you a notice that there's a tax due. Okay? And what some people do is they say, well, show me the law. And they're ignored. Let me tell you something. They were shown the law and didn't know it. Okay? What happens is that, go back to the definition of a court. It is the person and the suit of the sovereign. So, when you're accused of something, well, first of all, the accusation is not in court. It's just an accusation. But when it gets to tax court, what they will say in their papers that you're required to file taxes, and you don't. Okay? And they show the record. Well, look, they sent you a notice and you ignored it. You didn't pay. Okay, that's what they do. Well, the fact of the matter is that you were shown the law, because you go back to that statement that the decree of the sovereign makes law. So when the IRS put together its lawsuit against you, they make the decree right in the accusation. They say, you are required to pay taxes, and you didn't. Okay? That's the law that everybody's asking for, and they don't recognize it when they see it. So when you go through the process, you argue, oh, there's no law, when all the time there it was. And you lose. Okay?
Because the IRS has declared itself sovereign.
Well, at this point, yes. In truth, they're false sovereigns.
Yes.
There's no authority to take over the people. Okay? So, yeah. So the answer, if you have a serious case with the IRS, the answer is to do a counterclaim. And you challenge jurisdiction. Remember, when you challenge jurisdiction, everything in their case must stop until they actually prove that they have jurisdiction. Okay? That's the case law anyway. So, and notice the name. This court of record shall be known as the United States Tax Court. So when you write your counterclaim, you put that United States, not the Tax Court of the United States or Court of the United States. No, it's United States Tax Court. That's its name. That is not an Article 3 court. It's actually an Article 1 court. But the United States of America, through its Congress, has admitted that they're not going to follow that system. Instead, they're going to follow the system, the common law system of a court of record. Okay?
So when you ask them to show jurisdiction,
Well, yeah, you say, what's your jurisdiction? And they'll come up with some excuse. They'll say statute so-and-so, and all persons are required. Well, are you a person? Well, right. Well, that's a factor. But it's a court of record. And in the court of record, when you're counterclaiming, you're in charge. You're the judge. So if they give you a flaky excuse, your ruling will be they gave a flaky excuse. You're not sovereign. And where's the contract that says you have to pay the taxes? There's no contract.
so you win.
So you win the court case, you throw it out or whatever you do, and then they go back to their court case and you have this as evidence that it's null and void.
Well, yeah. Well, the thing is if they go back to their court, whatever they do, you use a writ of error because they are in your jurisdiction after you've done the counterclaim. They'll try to throw out your case. The judge might make a ruling saying that your lawsuit is frivolous and therefore it's denied. And then you issue a writ of error removing or rescinding that judge's decision. Why? Because this is a court of record and he has no authority to make decisions. The real reason is he has no authority to usurp the duties of the tribunal. Okay?
I got a question from the, is it okay to ask that right now?
Go ahead.
What are the essential steps to make a common law claim against another man?
Same as the essential steps of a regular lawsuit. What you have to do is you have to specify specifically the facts, what happened, okay? And then you have to specify that what your injury was, okay? Here's what was done, and here's the injury that resulted, okay? And then you have to say that that person that injured you did not have, or the other way around, has the duty to not injure you, okay? And then you say that he breached that duty, spelled B-R-E-A-C-H. The other breach has to do with canons. And then you say the amount of damages as a result, whatever it is, you put a value on it, and then you make a demand that he pay you. Those are the skeleton requirements of a cause of action. A cause of action is just a legal way of saying the reason you're suing the person. And incidentally, there are theories of law, and it's possible that whatever you're suing for, there might be different ways of looking at it, different theories. You can actually have conflicting theories. Each cause of action carries its own theory. And all you have to do is win one of them. You know, the fact that you have conflicting theories does not take away from the lawsuit. The one that applies is the winner.
So if you have somebody there, you get them to go to court, you're the judge and the jury and the plaintiff, and the other person can come in there with or without a lawyer.
So if you take somebody to court and they can come in with or without a lawyer, you're the judge, the jury, and the plaintiff. So you make this claim, you make the amount, and he's got to pay because he has no choice because you're the judge.
Well, he's going to answer. Might make a reasonable answer, might not. Okay? You don't just sue somebody.
Right.
You sue them and then you wait for the answer. And then if they got a crappy answer, you can reply. Critique their answer. Okay? In a lawsuit, you specify the law and you specify the facts. That's part of it. The cause of action has those elements I just told you. So you specify, you have law and facts as the main things. And when they answer, they can answer with their own law and facts. They can challenge it, Or they might even introduce new law and new facts, okay? So when you reply, you do not introduce new law and new facts. What you do is you reply to the issues. You had your chance with the first filing, okay? So if they bring in something new, you're entitled to deal with that. So you write about it, whatever your opinion is, why they're wrong and you're right. And so then you go to judgment. Now there's little side pathways. For example, discovery. That's a sideways pathway. But I never do discovery. The reason I don't do discovery is because I already got it all in there, right? I've already stated my case when I sue. I know why I'm suing. I know what was wrong. I've got the evidence. I don't need to look for more evidence. It's the defendants that have to look for evidence. They're trying to poke a hole in your case, and they want to see if there's something there that you're planning to present that would actually work on their favor. So discovery is useful for them, if in fact there's something to discover. So I don't bother with discovery. I don't bother with depositions, because my case is already made as far as I'm concerned. Okay. Now it gets a little more complicated when you're actually doing a counterclaim. They're suing you and you're suing back. Well, then when you're suing back, you definitely want to bring up jurisdiction, because if they don't have jurisdiction, then their suit goes nowhere. Right?
Can you go over jurisdiction?
What's that?
Jurisdiction?
You have a microphone? Here.
Can you go over jurisdiction?
Jurisdiction just means your right to attack them, or their right to attack you. A good example of that, let's say that you get in a fist fight with somebody and you punch them in the nose. Yeah, with somebody like that, yeah. So now his argument would be, you broke his nose, you owe him for that. So that's his jurisdiction, that's his reason to be able to attack you. But when you come back with your answer, you could say, well, yeah, I broke your nose, but I had to hit you because you attacked me first. Okay? So I have a right to do what's necessary in order to defend myself. And so that's why you ask for jurisdiction. You want to say, well, what's your reason? What's your authority to do that? There was a case where there's some contention between a guy and the federal government. It ended up the federal government sent a team to his farm, and they ended up, yeah, they killed his wife, they killed his dog, and because somebody got killed during the fracas, they accused him of murder, okay, or at least responsible, okay. The jury said he was not guilty. Why? Because it turned out this was a gunfight and the government shot the first shot. So he is not guilty. Okay, jurisdiction. They did not have the authority to go after him because they started the fight. So does that make sense? Okay.
So basically, if you start the fight, you have no jurisdiction to go after somebody for a fight you started.
Of course not. You never have the jurisdiction to start trouble. You know, you don't have jurisdiction to arbitrarily harm somebody. There is the Castle Doctrine. The Castle Doctrine says that if you're standing in a spot that's legitimate, nobody is authorized to move you off that spot. Okay? And you can do whatever's necessary to preserve your spot.
This is my spot.
Yeah. Yeah. And if somebody tries to move you off it, you could kill them if necessary in order to. Well, cops have been killed on that basis. They thought they were the do-all and be-all and tried to bully somebody around and whatever reason, and the person ended up killing the cop. That's too bad for the cop. He didn't have the jurisdiction because they weren't doing anything. There was no legal basis for a cop to talk to the person.
Like a squatter.
But they do that all the time.
Like a squatter would get away with a lot of stuff.
Well, whatever. I'm just saying, if there's no basis, then why is he talking to you? Cop can't even talk to you. Okay? He cannot talk to you based on his hunch. You might have done something wrong, and I'm going to see if I can get you to admit it. See, no, that's not permitted.
You need a very good thing about presumption. Is that about the woman who the game warden tried to arrest her?
Mm-hmm.
You need to say that.
Oh, you want that story on the record here, huh?
On record.
Yeah, it's I don't know if it's a true story, but I do know it's a popular story. And this woman, it was a beautiful day, and she was sitting in a little boat that they had at the lake, and it had fishing gear in it and that sort of thing. And the game warden comes along and says to her that, asks her, what is she doing? And she's thinking, well, obviously I'm reading a book. But she interacts with the officer, and she's saying, well, I'm not doing anything except reading a book. And so he's saying, well, he says, I'm going to have to cite you for violating the fishing laws, because here you are, you're in a fishing boat, you got all the equipment, and so I'll have to take you in. And she says, well, okay, but when we get there, I'm going to accuse you of rape. And he says, but I didn't touch you, I haven't done anything. She says, that's true. However, you have all the equipment and the ability to do so. To which the game warden replied, well, have a nice day, ma'am. Okay? You're not supposed to, let's put that, there's a difference between can and may. So you may not make an accusation based on speculation. You have to have solid facts. Okay? Again, what are facts? Things that affect the hearing, seeing, smelling,
Touching.
Touching or feeling?
feeling, right? That's the fourth one. Also, the state of mind is the sixth one. What your state of mind is. You're the only one who knows what your state of mind is. So,
I have another question
Yeah.
from online here. What if you settle with the IRS for a past debt? In the settlement, you agree to the taxes in the future. Can you sue to cancel that settlement?
well, you have the unlimited capacity to negotiate any contract that's legal. And there's nothing illegal about you agreeing that you're going to obey their rules. You're saying their rules are valid, so you're going to obey them. That's not illegal to agree. Okay? It's illegal to enforce an illegal rule, okay, but that's not the question here. The question is, Mr. IRS made up a rule, and you're agreeing, okay, I'll go along with those rules in the future. What's wrong with that? See? Now, if they used intimidating techniques, then it's no longer a voluntary contract. So you could break the contract because it was illegally brought about. So,
Under duress.
under duress, right? But you could sign it without prejudice, which preserves your rights. Now, without prejudice does not apply if you make a final settlement on a question. So when you're under duress, what you're saying is that you're agreeing only because the situation is such you had no choice. It was not free will.
Another viewer, Karen, says rescission of signature, question mark? And
Well, rescission of signature is just another procedure, okay? If you decide to rescind your signature and it falls within the rules of rescinding signatures, well, yeah, you rescind your signature. Now and you get the benefit of all that goes along with that, okay?
then she says, did agent of IRS explain that taxes are voluntary?
Well, again, that sounds like something that gets resolved in a court, okay? Now, the IRS used to have a policy statement very clearly stating that it was a voluntary system, but they've since changed that. They were getting beaten too badly on that one, so they don't say that anymore. However, in formal hearings, there's records, and in fact, there's even a pretty well-known document that made circulation where the IRS came into court and they filed a document which stated that the IRS was not part of government. It's a collection agency, okay? So that's been making the rounds. Again, you have to just look at what are the rules that you're working by. And there's lots of rules, but do they necessarily apply? The driving rules do not apply to the flying rules, okay? Separate body of rules. I call them rules, but statutes and codes, those are rules in a way. You have different bodies of rules, okay? We start off with the Constitution, and then under the Constitution you have the treaties. Under the treaties are the state laws, the state constitutions, the state laws. The federal government can make a treaty that effectively cancels out a state law, okay? So, and then under the statutes and codes, you have what are called they're called rules, but I'm thinking regulations. They're called regulations, okay? So you have for example, the Code of Federal Regulations. They call them CFRs, okay? The Code of Federal Regulations must conform to the statutes and codes, but they can't go beyond that, okay? But what it is that the legislature makes up all these things, and at some point the executive branch will decide the details of how to conform to the rules made up by the legislature. So when you see the Code of Federal Regulations, that has to do with how the administrative branch functions. When you see the rules of court, that's the court system conforming to the rules made up by the legislature. And the legislature has its own rules on how they conduct their proceedings, how bills get passed and what happens. And above all of that, of course, is the Constitution. So,
So when they say,
So when the cop stopped me and said my tail light being out, I was under suspicion of having broken a law. That's a code in the statute, which is trump. That's not a law, right?
well, it's not common law.
Yeah,
The word law without an adjective means common law.
right.
Okay, so you have statutory law, you have code law, okay? You have the law of the domicile.
Right,
None of that is common law.
I see. And common law is the Constitution.
No,
Okay,
common law is the law of the people,
okay,
and it's not defined.
Yeah.
It's the law of the heart, you might say. It's technically defined as custom and usage since time immemorial.
customary.
And that means, immemorial means we don't remember where it came from.
Right,
We don't know how that custom got developed. All we know is it did,
uh-huh,
okay? Why do you knock on the door before you enter somebody else's house? I don't know if that's specified in the statutes or codes, but I think it's definitely common law. You know, you walk into somebody's house is uninvited, all right? And then there's attempts to define, a lot of your statutes and codes are based on common law. But they're still statutes and codes, okay? They're not common law. So, I'd like to get into another subject here, called habeas corpus. Now, let me explain what habeas corpus is. What happens in the real world, in the Anglo-American system of law, is that somebody gets in trouble. And so let's say that the common law court is starting to act like an equity court. Okay, now they don't have jurisdiction to be an equity court. And still, they're trying to act like an equity court. So what a person could do is he could go to the equity court and say, hey, that court over there is muscling in on your territory. And they're trying to do equity business when that's really your job. So the equity court can take control of the case. They can take it. They can not only take the case, they can say, if the person's in jail, deliver the person to us. You have the body. That's how habeas corpus is translated. You have the body, so bring it on over. We will decide whether or not this is an equity case. And if it is, we'll take it away from you, the common law court. Okay? Now the opposite is true. If the equity court is venturing over into the law court area, a person could go to the law court and say, these guys are muscling in on your territory. They're equity courts and they're trying to practice law or apply law. Can't do that. So the common law court can order the case transferred to themselves. They can look at it, and if they decide, yeah, that's right, it is a law case, they can tell the equity court to go buzz off. Okay? So habeas corpus is that process of, it's like a family fight between courts. It is not a legal proceeding. It is not a lawsuit. It looks like a lawsuit. They use the same formatting and all that, but in reality, it's not a lawsuit. It is a privilege that you're exercising, a very strong privilege, okay, but still a privilege. And the Constitution specifically says that the privilege of habeas corpus shall not blah, 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 whatever, okay? So I guess it can be suspended in times of insurrection, something like that, but that's all. So the habeas corpus is the one right or privilege, benefit, you might say, to the people, that it's the only one that grew stronger with time. Now, why did it grow stronger with time when other rights tend to be diminished? It was because it was a great territorial preservation method for the bureaucrats. The law court says, hey, equity court, you're stepping on my territory. You can't do that. We're taking the case away from you. And just for good measure, the law court dismisses the case. You guys didn't know what you were doing. Bureaucrats love to put down other bureaucrats. Okay? Now, if you're the common enemy of the state or something, you know, that would have a different outcome. That's politics in a sense. So, but habeas corpus, that's what it is. It's a fight over jurisdiction. Who has jurisdiction over whatever the issue is? Okay? Habeas corpus applies a lot in California on issues where somebody is taken away for 3 days under the 5150 codes. In other words, they think you might be crazy, but more than that, they think you might be a harm to the public or to yourself. So a cop can arrest you, not for a crime, but for the fact he thinks you're crazy, and you need to go into the under psychiatric examination. And cops do.
Family thinks that about me.
What's that?
My whole family thinks that about me.
Your whole family thinks they're about you?
They think that about me. That I should be.
Oh yeah. Well, you got a problem.
They just convince the
So
cops.
how do they use habeas corpus in California on the
For getting a person out of the psychiatric treatment. They have to let you out in 3 days anyway, you know, unless they make a determination that yeah, you are kind of nuts. But not just nuts. You're actually a danger to the public or a danger to yourself. If they make that determination, they've got that temporary power. It's a power that's well abused. You know,
They're taking a lot of older people.
Sure.
They declare them. They get them declared incompetent,
Mhm.
and then they take over their whole.
or they take over their properties.
Yeah, and sell them and all kinds of stuff.
I'm in a very enviable position. I don't have to worry about that because I don't have anything. You know?
Alan, you need to have one of these ready at all times, so you can email it to yourself and file it right away when they take it.
Oh,
Under
yeah,
5150.
I know. I'm in
5150, it's a 72-hour
Yeah.
observation.
Yeah, it's a health and welfare code, section 5150.
Thank you for repeating that.
Yeah. So, but that's what habeas corpus is it's a question of jurisdiction. What is your authority to grab this person and put him in for psychiatric evaluation? Okay? And the usual basis for any court action is that somebody got injured. And that injured person usually becomes the plaintiff. That's the one who does the suing. Okay? So, it's a complex procedure. There's a company up yonder in San Francisco that specializes in habeas corpus, and they wrote a manual for to help. The manual is specifically written for people who are in jail to do their own habeas corpus. I have an old copy of one, and I can tell you it's excellent. It really is. And you're getting a new one, right? So, how much does it cost to get it?
$89.
Okay, $89, and it's cheaper if you're in jail. But if you're not in jail, yeah, $89. And I'm telling you, it's a great resource. There's, I think it's chapter 9, actually lays out the cases that you can use. And they will say, what kind of case it is. Let's say let's say you have incompetent representation in your case, and therefore they didn't really have jurisdiction or something like that. So, and they tell you exactly which constitutional provision covers that point, and they give you the actual wording to use, how you cite that case.
Bill, you said, it's to, for prisoners, but also you can use it to help somebody else.
Yes. In the law, in normal law procedure, one person cannot sue in behalf of another person. Okay? But the habeas corpus is the one exception to that rule. Partly an exception, the reason is because it's not a lawsuit. Okay? It's a family fight between two courts. And a friend can initiate the family fight, okay, but it's still a fight between the two courts, not between you and them. Naturally, you have to do the research and you have to put together all your arguments and that sort of thing. So it looks very much like a lawsuit, but technically it's not. So, and technically it's a privilege, not a right. But it's such a strong right, and strong privilege, that it looks like a right, So, definitely habeas corpus is a good deal. I'm going to take a byway here and look up the address. Here we go. We'll go to somewhere.
I have one question about habeas corpus. Isn't that also a procedure that can be used when you're a non-party to a lawsuit and you can present something to the court that then the other side can use as precedence or as some sort of fact?
Well, it's not precedent, because precedent only
Right, it's not
comes from
precedence.
appealable cases that have been resolved in the appeals. But if they can use it, why not give it to them directly?
For instance, I was told that, like, for instance, in the UN, if there's a hearing, you can use habeas corpus to present something that can then be considered when a decision's being made by, the voting.
I think what you're talking about is a procedure called friend of the court. So as a friend of the court, you can advise the court, and the normal procedure is that you make a motion as an outsider. You make a motion to the court that you would like to be a friend of the court. In other words, you have an interest in the outcome, not direct, but you do have an interest, and you want to advise the court why you think they should decide a certain way. The ACLU does a lot of that. They put a lot of friend of the court briefs in. Anytime you have gun issues, there's a whole pack of people, anti-gun and pro-gun both, that put in friend of the court briefs. So that's really what you're talking about, is being a friend of the court. But the habeas corpus is like a friend of mine got arrested, and I understood what the whole deal was. I put together a quickie habeas corpus for him, scared the judges, so they cut him loose. So anybody can do it on behalf of a friend. And the reason? It's not a lawsuit.
And a family member. And a family member as well, you can do it for.
For anybody,
Right.
yeah.
So what did you say, they got him off?
Oh, that's your money. No, but it is.
Okay. Yeah, no, anybody can do it on behalf of anybody in habeas corpus, sure. Because it's not a real lawsuit. I'll tell you another thing. If you have an administrative court, you have your three branches of government. You have the legislative, judicial, and administrative. Well, you have to be a certified attorney if you're going to represent somebody in the judicial branch. But anybody can represent anybody in the administrative branch. And so the administrative branch has its administrative courts. You can represent somebody there. You can argue their point. You do not have to be an actual attorney certified by the Supreme Court of the state in order to represent somebody in an administrative procedure.
What's an example of an administrative court?
Well, a perfect example is labor questions. Somebody goes to the court, to the administrative branch, and says, "Hey, I wasn't paid proper wages from my employer." Okay, that's not a court procedure. That's an administrative procedure. It can become a court procedure, but that's down the road. The first step is at exhausting your administrative remedies before you go to court. Okay? Well, it turns out they have an administrative court, which is, by the way, a highly questionable technique, but nevertheless, it's built into the legal system. And so, in the administrative court, which is under the administration, anybody can represent anybody. I've done it. My score is 2 wins and 1 loss. That was a long time ago. So, administrative procedures are not legal procedures. Okay? So, let's see. I want to show you something here. Oh yeah, I was going to show you the address of this thing. Okay, here we go.
Bill,
Yes.
you were looking for the address for the habeas corpus
Yeah.
handbook. If you go under your article habeas corpus, you click on that, it will take
Oh.
you to
Oh, that's
to,
right.
to Jason Campbell,
Thank you.
and there are 2 addresses.
Right. Okay. I will do that. That'll be better than what I was trying to do.
And the PO box, because I called and I was told there are 2 addresses.
Okay.
The PO box is the right one to send your check to get the habeas corpus book.
Yeah. And that what's on my website is a little bit old because the primary attorney and author of the book, I think has since passed away.
Yes.
And so and then he had a partner, and apparently that partner is not deeply involved anymore. So basically, a couple of attorneys inherited it, but I don't have the latest information on them.
I spoke with Jason Campbell. That's the lawyer that we send the money order or check or whatever to get the book. His name is Jason Campbell, and I spoke with him.
Mm-hmm.
And yeah, his address is on there.
Let's see. Here we go. All right. There it is. We go to habeas corpus on the website. And then,
Yeah, the habeas corpus handbook at the top. Yeah, habeas corpus handbook.
yeah, the habeas corpus handbook. Okay. Well, it's doing something. Okay. There it is.
John T. Campbell.
I don't have a box address on this.
Yes, someone is you click and it takes you to a PO box.
Well, you can buy it right there. You go above, and you can actually click on it and buy it. Brand new. There you go.
Yeah, the price is lower here on this one, but yeah, $89.
Prisoner discount.
You gotta be in prison.
Yeah, press,
They didn't give you a prisoner number?
Bill, click on buy now.
Yeah, I don't see the address here.
Yeah, if you click on buy now,
Oh,
yes,
okay. Buy now. All right.
buy now. Yeah, click on that.
I need somebody to tell me what's on my website. There's so much I can't remember.
They need it by now.
Here, California habeas corpus. Yeah, click on it.
There we go. Kent Russell was the original author.
Yeah. Okay, scroll down. Oh no, it doesn't have
It
it.
doesn't give you the check thing. Okay.
No, it doesn't.
Just through PayPal.
Yeah.
Credit card,
Oh, yeah.
It's,
they all take credit cards now.
Yeah.
you know, but the address is somewhere there because I found it and I called them and told them there are 2 addresses. And
Uh-huh.
the girl told me send it to the PO box.
Sure.
So I found it somewhere.
Well, down at the bottom, we have 300 Montgomery Street.
Probably is.
No,
No,
it's
it's
a
not
PO
the
box.
No.
You send it to a PO box. I don't know. I found it.
Something to research later.
Yeah.
Well, if you go back over the website, reinforce it.
Yeah. Oh, so
Yes,
what's the
so,
password?
yeah. Oh, you just call them up and ask them. I did that, and she said no. Send it to the PO box. I found 2 addresses, so how I don't know.
Okay, well,
And by the way, I received the handbook.
Yeah.
So that means the PO box is correct where I
Sure.
sent that letter to.
yeah. So you can, you'll be busy reading. But I'll
You
tell you,
bet.
section, the chapter 9, I think it is a gold mine of information.
I wrote that down.
Yeah, that, for citing cases. And I've used it in other cases, even though it wasn't habeas corpus, because those cases had to do with the issues, they did not have to do with habeas corpus, but they're supportive of it.
There's also forms you said that we can use. Form art, how to write it.
Yeah,
Okay,
yeah, it has suggestions on wording,
yes.
and, huh. Okay, next point, I guess, we'll go to that. Now, let's talk about forms. If you go to the Superior Court, for example, I'll go to Superior Court. Court. Santa Ana, California, forms. They have a ton of forms, okay? I mean, they got all kinds of forms for everything. Some of the forms are mandatory, some of the forms are optional. So you have to look in the lower left-hand corner of the of each form to find out if it's mandatory or optional. Let's see. Okay, here we have access to forms, and we have on the right, we have several kinds of forms. We have state judicial council forms, okay? Then we have local forms. Let's see. Okay. You have self-help form packets and you have locally approved form packets. So some things are very common to the local area that even though the state has not made up the forms, they made up their own forms, and you can use those. And again, some of those are optional and some of those are mandatory. So the courts have been paying a certain amount of lip service to in what they call self-help centers. The self-help centers basically is for people who don't have an attorney, who are trying to run their cases. So what they do, you go up to them, you stand in line, typically, and they have sometimes an actual attorney there who is trying to be helpful. And if it's complicated enough, maybe they'll let you see him, but maybe they won't even mention that he exists. But you ask them a question, and if they have a form right handy, they'll just give it to you. If you have a question about procedure, they're usually ignorant. They don't know. I walked up to it one time and I said, I needed a packet for habeas corpus because I thought one might exist. He didn't even know what it was. Okay? They're really not very helpful unless you're really, really, really ignorant. Okay? If you know just a little bit, your knowledge might be better than what they do at the window. So, they can be handy sometimes. Also, they're a resource. If you need a form, you can ask them and they hand it to you if they have it there. Okay, but the state judicial council forms is what I want to look at next. And here are the different kinds of forms. Okay, covering different areas. They have popular topics. That tells you they didn't cover everything. Okay, it's just popular things that frequently people are looking for. Quick access. So most of your battles will be in the civil courts. Now understand, there's different bodies of law. There's criminal law, for which you have the penal code. There's civil law, for which you have the civil code. There's administrative law, and so on. There's all kinds of areas. And so they will, they have forms for those different areas, and so there's an attempt here to provide it. But the civil law is probably what, if you're going to sue somebody, that's the area you'll be in. However, one other area is called common law. And they want to push everything into civil law because civil law uses equity courts, which are inferior courts, and the judge is the god of the courtroom, and he has a lot of freedom that he does not have in a court of record. So when you go to the courts, you go to file papers, all you will see is civil servants, okay? Not common law servants. They're civil servants. And these people, that's what they know is civil. They don't know common law. They're not attorneys, okay? And even attorneys themselves are deficient. They don't know common law. What they know is civil law. And the other thing that they get trained in is criminal law and some rules and procedures, that type of thing. The Constitution, which is the overall control, is not taught until their 4th year in school. They start with the details. They form their own idea as to what these details mean, and they get fixed into that mode of thought, and by the time they get to the fourth year, they try to teach them the principles, but they have their own ideas as what the principles are. So attorneys don't seem to have a good grasp of it. And the Supreme Court recognizes the incompetence of attorneys too, because here in California, an attorney who's representing somebody in a case is not allowed to enter the Supreme Court as an attorney representing somebody unless he has a minimum of 5 years of experience. So they're too new to the game, and the Supreme Court of California just doesn't want them in their courtroom. And we put together a case one time, and we're in front of this judge, and the opposing attorney, which I found out later only had 5 years experience, she says to the judge, "Your Honor, this case is calling for trespass and there's no property involved." Okay? Well, common law trespass means that there was force involved. Somebody got intimidated by the threat of force. You know, a cop wearing a gun on his side, that could be intimidating. And so you sue for trespass. She had no idea that trespass was not limited to property.
The word split fair, I guess.
Say that again.
Mhm.
Say that again. She didn't know it was limited to property.
Say it again.
What are you saying? She didn't know it was limited to property? Not limited to property.
It's not limited. Right.
There'd be force involved.
She thought that that trespass meant trespassing on somebody's property. Well, that's true. That is trespass, but trespass also is trespassing on your rights.
We forgive those who trespass against us.
Yeah. Yeah. Right.
No, no,
Well, yeah. That's
the Lord's Prayer.
yeah.
Lead us not into temptation.
That's the use of the word trespass that does not have to do with property.
Yeah.
So yeah. So she didn't know that. Okay. She.
She grew up playing with herself for fun.
So anyway, if you want to change your name, there's a form for that. If you want a guardianship, there's a set of forms actually. Are you changing your gender? They got a form for that. Okay. I guess it's been so well advertised that a lot of people, I guess, want to change their genders. Child support, civil harassment, conservatorship, lots of stuff. Divorce, elder abuse. I think if you're
Can your criminal record expunge it? Expunging?
expunging it, that would probably be in the criminal, that would relate to the criminal code. And if they don't list it here,
Right there.
not many people know about expunging a record.
Is it
But-
difficult?
Is it difficult? There's a cleaning criminal record right now.
Well, I don't think it's a difficult procedure. It may be a little bit political, okay? Because what you're doing is you're going to the court and you're saying, I'm really a good person now, and we should take away this record. So there are certain published requirements that are actually in the codes, which say, I think you have to have a clean record for 10 years, and you cannot have been convicted of another misdemeanor. You're trying to get rid of this misdemeanor. Felonies, that's a different story. There's more requirements. But at least the state can be forgiving. And of course, the ultimate expungement is to get a pardon from the governor. Trump says that he's going to pardon all the J6 prisoners.
And himself.
Well, that was, I'm not sure if Nixon did that, pardoned himself, but I do remember it being discussed, and I do remember that they were thinking about making that illegal, that a president could not pardon himself. And another deal is pardoning a person in advance of conviction. And I don't know that that's really, I don't think it's proper.
Didn't he do that? Didn't Trump do that also? He said if you guys,
No, he hasn't done it yet.
but he said if you stand by me, I'll make sure you're expunged, be loyal.
Well, whatever, you can do anything as long as you got the partner on your side.
Bill, can I ask a question regarding that? DC is a foreign territory. So the demonstrators that went there were on foreign soil. Is that right?
I think it'd be more accurate to say you're not in one of the states. It's not a state itself. See, the problem that they had, you remember I said that we had to have a government so strong that it could keep at bay the other countries that would be only too happy to take us over, which at that time was England, France, Spain, and Mexico. Okay? But the way they did it is they basically, what they said is that when you're inside the United States, the 50 states, we're going to work according to law. When you're outside of the United States, we're going to work according to power. So, because in international law, you may have to do things that wouldn't be lawful inside the states. Now, if they make District of Columbia a state, I wonder if suddenly that takes away the power away. Because if it's a state, it could not do certain things that are reserved to the federal government. So now is the federal government and District of Columbia, are they the same thing? Or is the District of Columbia a higher value or a lower value? I don't know, but those are legitimate questions.
Bill, a couple of questions online here, and they're not timestamped, so I don't want to distract from the current topic, but
I don't mind.
the question is DMV court, question mark? And then is a DMV hearing an administrative hearing?
Yes, it's a DMV hearing. The DMV's in charge. Okay? Now, here's a little problem, though. When you get a traffic ticket and you go to court, is that a court a judicial court, judicial branch, or is it an administrative court? And the thing is that in an administrative court, whatever the judge says can be arbitrarily reversed by the top guy on his own single decision. He can reverse the court decision. And I know a guy who had his license suspended like 30 years ago, and alcohol was involved, and he's been trying to get his license reinstated. And in DMV, he actually has a judgment from a judge saying that all rights were restored, and the DMV still won't renew his license. Okay? Well, it's unfair, but that's what's happened. So, yeah, the administration, you have a little problem here. It's called separation of powers doctrine. So you have your three branches of government. Those are three separate powers. And there's a little bit of interaction. For example, the administrative branch of the federal government can present candidates for the Supreme Court, but only the Senate can approve them. Well, the Senate has to be somewhat respectful, even though they have the decisive authority, because what if a certain power was effective in the Senate, but the administrative side refuses to present any candidates? See? So we have in our system certain clear definitions, but then we have these little cross connections that kind of encourage people to be courteous to each other. You can't just run away with the power that you have.
You said your friend had a judgment against the Department of Motor Vehicles. The judge restored his rights.
Yeah.
The motor vehicles won't acknowledge that. Can he then go after the individuals of the DMV?
Well, I suppose you could. You know, let's put it this way: you could file a lawsuit. Okay, somebody's not going along with the judge. On the other hand, maybe the judge doesn't have the authority. Maybe it was an administrative court. See, so these are all questions that get settled in court.
Add-on would be, is family law administrative?
No. Well, it can be. I mean, you have child protective services, right? They're administrative. But yet, when you get into court, this court process, maybe. Because sometimes these courts, you're in the court building, and yet they're operating under administrative authority rather than under their, what you would expect to be their normal function. And this is not an accident. This is intentional. The government lives off of your lack of knowledge. Okay? Confusion is good for the government because that makes it easier for them to be arbitrary. So let's go to the civil here, since that's the one you probably will be most involved with. And so now here's a list of forms, and this is called, let's see, okay, civil harassment restraining, okay? So you can pick, if somebody's harassing you, you can click on the little box that says form issue. Whoops, I messed up on that one. Yeah, there you go. Here's a request for civil harassment restraining orders. So you get an order from the court to order somebody to quit harassing you. Although I did read a case where this woman got a restraining order from her ex-husband or boyfriend or whatever he was, and he showed up. She showed him the order, and he grabbed it away from her and stuffed it down her mouth. So I have a feeling that he was incorrigible.
Bill, maybe you can answer this question. Why is it that, now you have the DMV and other agencies having so many different languages on the forms?
Why do they have so many different languages?
Yeah, okay, if it's a English-speaking country, there's no other country that does this, where you go into another country and their forms are in their native language. And here in America, you have every language possible for.
Well, not every language, but definitely different languages. Here's a short list.
Yeah.
Chinese, Korean,
Right.
Spanish, and Vietnamese.
Why is that?
Well, it's because they're there. There's so much.
They're the ones that get harassed the most.
The official language here is English, but there's so many people with these problems that they have interpreters. Okay, you to be an interpreter, you have to get certified by the state of California. Okay, you can't just be an interpreter in a court.
So I guess it's all monetary.
It's what?
All monetary purposes, benefits.
I didn't understand.
It's all about the money, making money off of.
Well, that's another factor that's true. In but anyway, the point is, there's so many Chinese there, such a large population of Chinese, Korean, Spanish, and Vietnamese that they had to do something so to accommodate it. But English is still the official language, and I know that if you are presenting a foreign language document to the court, you have to have a certified translation into English. Okay? So English is our main language. But anyway, there's an example of a form. And we'll expand that a little bit. Let's see, there it is. Form CH-100. Asking for a restraining order. And they get so many of these cases that they try to put them into a standard format. The judge becomes familiar with these formats. It's easier for him to handle a case if everything fits into a common pattern. So, here we go. Okay, we got civil harassment form packets and how-to instructions. But I told it to deliver the form. Well, I guess I don't have it. Didn't download.
Bill, another question from the same viewer says, what about child custody case? Can you detect if they're doing an administrative process, or I think he means a court of law, he means legal, I'm not...
Well, they don't brag about whether or not they are an administrative court or an actual court. But if they are an administrative court, they work real hard to make you think it's in the judicial branch, okay? They try to keep you ignorant. I can say this, that this is probably one of the worst areas of law in our country. There is such a lack of integrity in how these processes work. And there was one case I was involved in, not personally, but helping a person. And they took this woman's baby away from her, and they're supposedly taking care of the baby. She had visiting rights. She could visit the baby. And the baby developed a rash. And it was just getting worse and worse, and she wasn't getting treatment. Okay? And she complained about it. They did nothing. And when she went to court, the judge didn't pay any attention to that. And she obviously had taken better care of the child than the Child Protective Services did. So, and it was really worse than that. She went and visited her child, who was at that time about, I think it was 5 years old, 4 or 5 years old. And when she showed up, the little girl ran over and picked up a play phone, picked it up, and she said that the name of one of the government officials, she said the name of that person, that person told her to call the police whenever mama showed up. And had a play phone. Okay? They were actually training the child against her own mother.
What they did to my daughter in school.
Well, school's a little different situation, but yeah. But now, they're replete with problems. There was a family that really did battle, and they won. And so they had a court order that the child had to be turned over to them. So when they went to pick up their son, they were informed that, well, they had a parking lot accident and he got killed. okay? They were not going to let him have the child back. And in another case, and this one got to be pretty famous, this couple, they did big time battle and were pretty much holding their own in it. And one day they got in the car, they started down the road, and a bomb had been placed under the car, blew up. It's severely injured, but it did not kill him. So the police, of course, show up at the bomb site, and they were arrested for transporting explosives. Okay? And this is all obviously coordinated. There's groups of people who, associations of parents who have tried to fight this. I think it was Michigan, they did discovery, and they found that they found a memo from the head of the department instructing the employees to go out and find more kids because they had to meet budget expectations because they get money for each child that they take. At that time that I was involved, which was about, I guess, 8 or 9 years ago, at that time, each child that they took resulted in $50,000 a year from the federal government to the state. And if the child had any disabilities, it went as high as $150,000 a year. And I think it was either the state of Washington or the state of Oregon at that time, they got caught causing malnutrition in the children so that they could be recategorized into the higher level. You've heard that case? Or familiar with that? No? Yeah. Yeah. They are absolutely, I mean, you talk about lack of integrity. Yeah.
Similar thing with prisons too, right?
Pardon?
Similar thing with prisons too, I imagine.
Well, prisons are pretty bad, yeah. They don't really do a good job. You know, you talk about rehabilitation. A friend of mine used to tell me about when he'd tell me he knew somebody who went to prison or something, but he wouldn't tell it that way. What he'd say is, well, another friend of mine went to college.
Hard knocks.
Yeah, they refine their criminal skills. So anyway, this is where you find forms. For some reason, this didn't respond, so I'm backing off of that particular form. So I'm going to try another one. I already tried a different route. Here it is, download. And that one seems to be working. So, in all of your forms, you have certain elements that you always have to have. You have to identify the names of the parties. You have to identify which court it is and what the address of the court is. You have to identify if there's attorneys, and then you got to identify what the issues are, that type of thing. And so, basically what it is, they're all basically the same idea, which is you're asking the court to do something in your behalf. The other person who answers is asking the court to deny it and maybe give them something or some result that they want. And you state your case in your document, they answer your document, but then they may bring in new information in their own defense, but nevertheless new information. So when you reply, you can only reply to the new information, okay? Or you can go counter to existing information, but you cannot bring in new information on the third step, okay? Now, when you do a lawsuit, you have I went through the checklist of things, but important is what the law is and what the facts are. That's what's important. And when they answer, they can answer against the law, saying there's other laws involved, and they can also answer on the facts. Okay? That's an answer, and then you reply to the answer. Well, instead of answering, the answer has law and facts, they can do what's called a demur. A demur is when they only answer the law, but don't talk about the facts. Okay? In a demur, they are agreeing that all the facts that you provided are true. The only question is how the law is applied. You remember the earlier example. Party A punches Party B in the nose. Okay? That would be ripe for a demur, because the party B does a demur where he says, well, the law permits me. How does that go? No. Oh, I've got to get my parties right here now. Party A files a lawsuit because he got punched in the nose. Okay? Broke his nose. So Party B could demur and say, yeah, that's right, I punched him in the nose. The facts are correct. And if he doesn't say that, it's implied in a demur. But the law says that I'm allowed to defend myself, and too bad for your nose. Okay? That's what a demur is. A demur is actually half an answer. It's the law half. Okay? The accusation had law and facts. The demur has only law, whereas an answer can have both law and facts. So, under common law, see, in statutory law, when the person does a demur, it's almost treated like a first action. It really isn't. It's a response to your complaint. But it's treated as a first action because the statutes require that you answer. You provide an answer to the demur. Otherwise, you automatically lose a demur. Under the common law, no answer is required to that demur. Under the common law, you go to first the accusation, and then the defendant demurs. Guess what happens after that? The court looks at the demur, all the papers in fact, and it has a choice. It can either order a trial, or it can go straight to judgment. And I love demurs. Attorneys do demurs all the time. You know why? Because they make money. Every time they put a paper in, their client has to pay them. Okay? So they do demurs all the time. No attorney seems to take advantage of the fact that the other side, by putting in a demur, is admitting all the facts are true. But when I write a paper, if they demur, I make hay with that one. Okay? Oh, you already admit it, and then I produce a judgment. I've shortened cases that way. And they don't know what to do, you know. But I always hope they demur. Okay, and then I go straight to judgment, and remember, the plaintiff in the law case is the judge. You know, if you're in common law and you're in your sovereign capacity and all that. So here you identify yourself, the person that's seeking protection, okay? You have, right here, the court is identified on the right side, Superior Court of California, County of, and you fill that in and you put the address. And then you have the case number, if one's assigned. And it gets assigned at the time you file it. And then you got to name the person that you need to stop from bothering you. And then there's other people like, your children, you want them safe too from that person, so you can list that. And you go through. Now, if you look down here in the lower left-hand corner, it says Judicial Council of California. Real tiny print, isn't it? Now, let's see.
Website.
Okay, so in the California courts, it's the Judicial Council of California, and it deals with it, and it says here it's a mandatory form. So if you want to argue that issue, then you use this form, and there's no exceptions. One of the things that you have to do is if, let's say, you remember I talked about the unlawful detainer and how you handle it by doing a quiet title, okay? Two separate cases. When you file the quiet title case, you have to put in a notice of a companion case. And you let the court, the quiet title court, know that this other case involves the same parties, the same or similar issues, only in the quiet title case you're arguing title, whereas the unlawful detainer you're arguing possession. Okay? So you have to let them know. So what you need to do, and I strongly advise this, if you're really serious about your lawsuit, you need to educate yourself. And the simplest way to do it, well, maybe not the simplest, but definitely what you should do, is you should read the books. Okay, if you have a common law case that looks like a civil case, but it really isn't, you still read the civil code, because the civil code tells you, covers different issues. And even though you're following common law, this tells you what's important. Okay? They lay it out for you. They say that when you make a complaint, you have to, or they say what it is that you're complaining about. They give descriptions of what the law covers, meaning the equity law. Okay? So that you actually need to read every bit of the civil code that covers your kind of problem. If you're in a real estate, there's a whole section dealing with real estate. If you're dealing with, what was the other area that I was thinking of? Civil code. I can't, suddenly it escaped my mind. But the thing is you look up that area and you get some strong information. And the civil code covers civil procedure, and when you put in your common law case, all the personnel will look at it as if it were a civil case because they don't know. Okay? They don't know the difference. And they think, oh, here's a civil case because it's not criminal, right? That's how they think, criminal and civil. They don't know anything else. So that's one of the things you do with the reason I'm pausing here is because when you file a case, you also have to file what's called a civil cover sheet. Now your case is not civil, but they still require a civil cover sheet. But when you're checking off the little boxes as to what kind of a case you have, you should check the miscellaneous box. Because why? It's not a civil case. It's a common law case. Well, they don't get many common law cases, so it is miscellaneous from their point of view. Okay? The civil cover sheet is, the purpose of the civil cover sheet is to keep statistics. They like to know what kind of cases they're processing. And so I've noticed that the federal courts have quit quit requiring you to declare your answers being made in under perjury, penalty of perjury. Okay, it has nothing to do with your case. It has everything to do with them just tracking what kind of cases you're running through the place. Okay, so at least the federal court has shown some sense in that department. The federal courts they're pretty nice people, by the way. When you go to file cases in the federal courts, they're very courteous, very friendly, okay? At least until you have a contention of some sort and it develops into a fight. But generally, walking in the door fresh, they're very helpful. Again, they won't give you advice, but if you ask them a question, they'll tell you their requirements, and they don't seem to have any problem telling you what the requirement is. With the state clerks, especially the ones in Los Angeles, because I've been there, they're kind of obnoxious sometimes, you know. And this is what you get. There was an experiment one time done with rats, and they had, I forget what it was, maybe 1,000 rats, something like that. They built a giant cage and had them, and they fed them, and they kept feeding them, and the population increased. Now, rats are unique in that they're highly social characters, and when a population became too crowded, gangs developed, and gangs would go from one area to another area and actually rob and kill. Okay, and then what they started doing is they started restricting the food. They didn't starve them to death, but it cut down the reproduction rate. Okay, and when the population came down to the more normal level, then all that crime disappeared. Yeah, so it was an interesting experiment. So, but
I've got a question,
Yeah.
and it's regarding CH 100. So if you file this, and then it turns out that you made false statements on your claims of being harassed, and you even admit it to a judge, what happens to the petitioner?
well, first of all, you would never admit you made a false claim.
But if you did,
That's a confession.
right? So, but if you did, I know a case like that. That's what I'm saying. So if
Well-
you did, then what happens?
No,
It got thrown out, but nonetheless.
well, you might go to jail. You know, and it's illegal to lie. You can't lie. Okay, if you're stating when you go under penalty of perjury, you're saying it's okay to put me in jail if you catch me lying. You don't do that. You can make mistakes. Okay, that's okay to make a mistake, unless they prove that it wasn't a mistake, that you really did it on purpose. So, no, never lie. Let the chips fall where they may.
So what if you're on the receiving end of a complaint like this, and that happens to you, and they literally admit in court that they lied? What do you
Okay,
do?
when you go to court, this is a rule of thumb based on hard experience. Never, never, ever say the opposition is lying. What I have noticed, and I've seen this in not only my cases, but other cases, I eventually caught it. I figured it out. When you say the other side is lying, that constitutes a judgment on your part. Okay? You have concluded they're lying. But that's not your job. Your job is to present the facts, and the court decides whether or not they're lying. So what you do in your paperwork, you say, well, they said this, but here are these facts, and they're not compatible. They don't look compatible. It appears to me there's a conflict between them. Say, it appears to me. You don't say that it is a conflict. You say it appears to be a conflict. Otherwise, what happens is that they decide against you. Whoever says the other side is lying will lose. This is what I've seen happen in court. I don't know how that philosophy came about, but it's there. So always, one of the things you want to be very, very careful of is not to make decisions for the court. You know, if you have a judge who's actually making decisions in your case, let him make the decisions. Bring
So
it up.
if the judge determined that the petitioner lied, what is the judge supposed to do, or is that up to their
Well-
discretion?
Well, he's vested with discretion. You might say it's a small point, don't worry about it, or you might actually have the person put in jail or in contempt of court. I mean, that's not a predictable result because it's up to the personality of the judge. There's a tendency to not follow through on perjury because it means more paperwork for them. Okay? They don't like to work. And, you know, you put a person in jail, it falls a lot. It's expensive. So on something like that, I mean, remember, it's the job of the judge, or the court, actually, to determine whether or not the other person is telling the truth. Okay? That doesn't mean they're lying, but it may be that they don't have their facts right. But the court has the discretion to decide the credibility of the witnesses. Okay? So even though you cannot directly decide a person's lying, the court can decide that, well, they don't seem so credible. There's doubt. Okay?
So am I understanding right? If you say you had a contract with somebody and they didn't fulfill their contract and they kept the $10,000 that they charged you for this contract, you could take them, you could fill out one of these forms that says civil on it, but you actually put miscellaneous, and it becomes common law court.
No, it doesn't become common law. What makes it common law is what you put in your lawsuit. And remember this, all these forms have boxes, don't they? Places where they specify you put in there. What you can do is you can say in the box, you can say, see attachment. And that opens the way for free form. You're limited to the subject, of course, but
Because I thought it was like a whole separate filing area.
So in the case of this form,
yeah.
in the case of this form, if you make it common law, who's going to be the judge? Who's going to be you are?
Of course.
This is a restraining order.
If you are the plaintiff, yeah. But now you come to another problem. It's not signed by the judge. Okay. You're going to have trouble enforcing that with the sheriff. All right. There's some areas, look, the common law is not everything. In theory it is, but in actual practice, sometimes it's actually better to follow the statutory route. Got a clear-cut case. One of the worst courts you can go to is a small claims court. Those judges are not the best judges, not normally. Sometimes a Supreme Court justice will sit in and be a small claims court judge, but that's just having fun, okay, for him. But I remember one case where I was working for a private investigator, and he hired a firm to do some promotion for him. And he didn't ever really get any results. There's a real question as to whether or not they actually did distribute the flyers. So he went to small claims court, and we, of course, were very careful. We wanted to make our case, all the facts and so forth. So I take that back. It was the firm that was suing him for payment. So when we get to small claims court, the advertising company made their case, but they got interrupted. And the judge really started severely questioning him. And toward the end, it came out that the judge himself, during an election, had hired a firm. He was not happy with what he got, and anyway, they lost. Different firm, totally improper in terms of court procedure. But we were lucky. We had a judge that he had a thing against these advertising firms. So, you know, there's so many things that can happen in court. You know, when I was putting together one case, I had an attorney review what I had done. I had another attorney also review it. They'd red pencil it, okay? Neither attorney knew about the other. I was being cautious. And then I had a secretary review it because she understood, or she was a normal secretary, and so I wanted to know if a normal person could really understand my writing. And then I had another person who was really, really good at English. I mean, he would tear my writings apart. He was just good. So I go to court with these papers, and the judge leans back. He's relaxed, and he says, you know, he says, you're here without an attorney, and I'm bending over backwards to give you every benefit of the doubt. But he says, I don't understand your paperwork. Would you explain it to me? Well, I understood him. What he was saying was, you ain't going to win in this court. Okay? You get stuff like that. One time I went to court just as a watcher, seeing what's going on. And this friend of mine, it was a tax case, and he was arguing against the taxes. And he was actually appealing a ruling in the trial court. And the appellate court judge, he actually said this. He said, don't you understand how we get paid? And of course, he lost the appeal. But can you imagine? I mean, that was just raw exposure, you know? Okay, well, anyway.
So I still didn't really get the answer to that question. So you fill out these civil papers, and you fill out the civil papers, and you hand it to the civil court, but you put an attachment and say it's for common law.
Sometimes the forms aren't quite right, and so you want to make your point, and so you would use that method of getting it in.
And do they have a contract? One's going against contract? Do they have a form for contract?
I don't understand how contract fits into this picture.
If someone didn't fulfill their contract that you signed and paid for, and now you want your money back?
Yeah, well, that's, of course, not a civil harassment form.
No.
No, but,
But one of those civil?
well, in a case like that, I would just use my own form. Okay? You know, I would just use a basic form. And I should show you an example of a basic form, okay? Computer's taking its time. Okay, it does that.
And then you turn it into a separate department, the common law court.
No, you file it with the civil clerk, because they don't have a provision for common law clerks, okay? They want everything to be civil anyway. So you have to put it in as a miscellaneous form or something that implies that, okay? Because it's not an actual civil case. Okay, so I'm going to show you a normal lawsuit form, okay? Okay.
And is there a statute of limitations?
But
Is there a statute of limitations on the?
statute of limitations, I
Common law?
respect, but you're not obligated because there are no statutes in common law. Okay?
Let me write that down. That's an important note.
That's a very important note. But you should do your stuff timely. You know, you in a small civil event, you might have a statute of limitations of 1 year, or you might have 2 years. Now, in common law, you could come back 5 years from now. But I wouldn't do it because you'll have everybody fighting you. They'll even break the law to resist you. So,
Judge.
yeah, even the judge.
No,
So
but you're the judge in common law, so how are they gonna fight you?
they run interference. The judge will make decisions. Okay, and now you're forced to find him in contempt of court or something or whatever. You know, it just increases the fight. Instead of increasing the fight, do it timely. Okay?
So let's just say, for instance, if Alan got arrested and it was more harassment than anything else, and they dropped the charges eventually, he can come back at any time under common law and sue them for wrongful detention, arrest, and all that?
Yeah.
There you go, Alan.
All right, well,
That's from like 30 years ago.
Yeah. Well, like I said, you'll get a lot of resistance, and if it really was 30 years ago, you'd probably find it impossible to get people to cooperate with you. You know, it's just you got to be timely, okay? What you're saying by not being timely, what you're saying is that, well, it wasn't really that important.
Well, he was under so much distress, it cost him mental anguish.
The therapy just finally finished 30 years later.
Well, okay, you know, you can.
It's still going on.
I guess you can find all these excuses, you know, and for that, but
It's your court at the end of the day.
you know, the whole idea is that if you got a fight brewing, settle it as fast as possible. Don't let it drag on for years. You know, it's just it's really kind of unfair. But okay. Okay, I'm bringing up a writ. Doesn't matter. They all have basically the same format. Okay. Here's a typical format for a lawsuit, a writ, a motion, whatever. You have your name and your address in the upper left-hand corner. Now, this is California style, and a lot of states use this style. There's another style that other states use, but that seems to be the two basic styles. Well, this is California style. And so you have here the name and address in the upper left-hand corner. Then you have the name of the court. In this case, it was the District of Nevada, okay? Same as California. And on the right side in the upper right corner, that space is always blank because that's where the clerk puts the filing stamp. When it gets filed, it stamps the file. Then, under the name of the court, you have the name of the petitioner. Now see up here at the top, that is not the name of the petitioner. What that is the name of the contact person. Who do we contact? You're letting the court know who to contact up here. And normally, it would be either the party himself or it would be the attorney. Okay? So that's normal for the two, but the whole purpose of that corner is to let the court know how to get in touch. Okay? Then, so down here now, we have, on the left side, you have so-and-so petitioner versus so-and-so respondents. That's your normal format. And then you have a vertical line, separates the two, and that vertical line is not mandatory. It's customary. You'll see it on all the forms. But it separates the next element, which is you have the case number, and then you have the name of the paper. This particular form, we have a judicial notice, judicial cognizance, finding the fact, writ of error, cui coram nobis resident, and order to show cause. And those are all different papers, okay? Having said they're different papers, it could be one paper, but different sections. Okay, you can put multiple papers into one paper and just call them sections or so. So, but that's where the whole purpose of this is the title of the case. A person can look at this and say, oh, okay, I got a sense of where we're going with this. So you would put there, for example, complaint, or you could put down action, or action at law if you wish. You can put in answer if you're doing an answer. Same format. See? In all organizations, they have formats in their paperwork, and this is the typical court format. So if you're trying to do something and you choose not to use the form that they provide, you can look at the form and see what's required, and you can put it in this format, and that's okay. The exception to that is that sometimes in the lower left corner, they say it's mandatory to use this form. And then you can't get away with that. Okay? So now, in this particular case, having done that, the next thing is the section. This is where you tell your story. Okay? Since this is a combination of a bunch of things, we look down here, and this is pretty typical. It comes now to the court on its own motion. See, the court itself can make a motion, and then it turns around and it judges its own motion. But in this case, this is apparently something against something, whatever, and the court itself sees the necessity of doing it itself and not waiting for one of the parties to do it, whatever it is. So it starts off, comes now to the court on its own motion to review the facts, record, and process resulting in the minutes of the court. And it has number 1, which is probably an exhibit number, filed on such and such a date, and so on. And so you tell your story. So you have the introductory paragraph, you have what the summary is, then you go into more detail maybe. And these are just suggested headings. The thing to understand is in your paperwork, headings do not count. Okay? A heading is legally meaningless. The purpose of a heading is to give the reader some clue as to what they're looking at. That's all a heading does. It does not affect it. The only thing that's important is the content of the paragraphs. That's what's important. And like one of the things I've done, for example, one party did I think it was a demurrer, okay? And then I looked it over and I reclassified, because I'm the decider, right? I reclassified it as an answer. I said, this isn't a demurrer, this is an answer. Headings didn't matter. They called it a demurrer, but it wasn't. It was actually an answer because they were arguing law and they were arguing facts. Demurrer, you only argue law. So it was clear they didn't know what they were doing as far as naming it. So you have that flexibility to look at the real world, okay? The courts are not all just fluffy theory. It's actually, you can deal with real world issues. I got to tell you about this one paper. This party called up the opposing attorney. And the opposing attorney was a lady. Well, she didn't act like a lady, but she was a lady. He would make a point, and she would say, that's horseshit. And make another point. She'd say the same thing. And finally, when he made his last point, she said, that's a bunch of horseshit. So this particular paper we were writing was supposed to be a report to the court in preparation for a hearing. Okay? And it's called a meet and confer requirement. Anytime you have a hearing, before the hearing occurs, the court wants you to get together with the other people and see if you can somehow settle it, rather than take the court's time. And so that's called a meet and confer. And you can meet and confer on the phone, or in person, or by writing even, letters to each other.
Is there a mediator present?
What's that?
Is there a mediator present?
A what present?
Mediator.
Mediator.
Oh, no, the judge is the mediator.
In the meet and greet?
Well, no, and the meet and confer, it's just you and the other party, okay? They just want you to get together informally, okay? But then you have, after you meet and confer, you write to the judge or to the court the results of your meeting. Sometimes it's nowhere. In this case, I was writing up that report, and I designed it, the report, so it took exactly 1 page, okay? And I related the conversation, and I actually put the dirty words in the paper, okay? It's a quote. It's what she said. The very last sentence, I said, "It appears to this writer that the attorney was suffering from a severe case of vowel motion." Vowel motion.
Just a little housekeeping question. So if you're filing, let's say I have elderly parents, can they give me a power of attorney to actually be the judge and
No,
petition?
power attorneys are not recognized in the courts if you're talking about representing a person.
Right, what I'm saying about in common law, there's no power
No,
of attorneys?
there's no, well, in the common law, when you're the sovereign, you can make your own rules.
So they can
but-
appoint me as judge, basically?
Well, look, I suggest that as much as possible, you follow the civil rules, okay? Follow the court, they have what they call rules of court, okay? You should read those rules, and you should read the whole book, all right? It's a lot of reading, but if you have a case going, whatever area it covers, you should read the materials. And of course, you're not going to remember everything. And of course, you're not going to understand everything. But at least read it and get eyeball exposure. And when you read it, sometimes things stick. So I had one guy I was talking to, he got some advice from a friend of his that was a judge. And the judge asked him, he says, "Would you like to win every case?" And he said, "Obviously, yeah, it'd be nice." So the judge said, "All you have to do is read the evidence code, because they always mess up on evidence. So if you know the evidence code, you're going to win every case." That was the promise of the judge. So I'm passing it on to you, but I'm expanding it. I'm saying, read the rules of the court, and you'll find things, a lot of detail. For example, the margins on the page should be 1 inch wide, okay? You have to have 12-point type. If you use the variable spacing type, then it has to be 14 points. So you got to read these things. One guy was really hated by the courts, and he filed a paper in, or tried to, and the clerk rejected it because half a character went over that 1 inch margin. So they wouldn't let him file it. But there's another rule in the California system where if you're filing something and you're up against the deadline, the clerk must accept it so that you meet the deadline, even though there's an error that's not acceptable to the court. And of course, if you really know you're right anyway, and you realize that the court's ignorance was getting in your way, or maybe prejudice, what you do, you say to the clerk, "File on demand." And they have a little stamp, they pull it out, and they stamp your paper, and the black ink says, filed on demand, okay? What that does, see, they rely on the clerks to help keep things straight. And the clerks will reject your paperwork if something doesn't match up. And that's a good service. I mean, it can be helpful. I've gone back 2-3 times sometimes on a complex case where the clerk actually, by rejecting it, was actually telling me what I had to fix. So, but if you really know you're right, you say file on demand. And what happens is that takes the clerk out of the way because she's instructed to filter this, but you took away the filter. Now she has to take that paper and forward it to a judge who is educated in the law. He'll look at it and he'll let the clerk know whether or not to file it. So that's a useful function. And sometimes if you're running into clear prejudice, I say file demand on demand on all the papers. They don't like that because it's extra work for the judge. So you'll find that in the real world, there are variances on how you do things. But you have to have a foundation of theory first, okay? Here's an important thing that you should know about anyway. Judicial cognizance. You've heard of judicial notice, maybe? Some of you have, some not, maybe. Judicial notice means that you're telling the court that there are these things that the court should notice, should take into account. The key word is should, okay? They don't have to, but they should. And on appeal, that word should might have a little stronger value, maybe not. Judicial cognizance is different. And as it says here, judicial cognizance is judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. He can't ignore it. He must, whatever he decides, it has to be compatible with whatever he's taking judicial cognizance of. And so what we have here in this particular example is basically the law of the case. We use a different title here, judicial notice and judicial cognizance. But usually I call it the law of the case because as a sovereign I'm decreeing what the law is. Okay? And so I start listing the laws. And it says, I quote in here the preamble of the Constitution, we the people of the United States, and so forth. That recognizes my sovereignty. See, I'm the creator. And the very meaning of sovereignty is that the decree of the sovereign makes law. So here's the cases that support that, all different cases. The courts have recognized that you're the sovereign, you decree the law. Okay? And this is really a good one. The people of this state, as the successors of its former sovereign, that was King George, are entitled to all the rights which formerly belonged to the king by his prerogative. What are your rights? Your rights are whatever you say they are. And there is only one limitation. That one limitation is you cannot step on the toes of another sovereign. Okay? There's an invisible border between you and all the other sovereigns. But, so your rights are whatever you say they are. And the Constitution recognizes that. I think it's the 9th Amendment, which says, or the 10th, I get them confused a lot. It says that just because we listed this Bill of Rights, that does not mean that the state can ignore or the government can ignore the other rights that were not listed. But what are those other rights? Well, only you know. Only you know.
That's on the website, right?
No, this is not.
No. This is,
Oh.
this is just something I pulled up as an example. There is a couple of examples on the website, and I think they have the law of the case with them. Now, the law of the case is not the same for every case. You have to decide what's applicable and what's not. So what you're seeing, and what you will always be seeing, is a limited version of the full panoply of whatever you think your rights are. And so it says here, the king's judges are the mirror by which the king's image is reflected. Now that's actually an equity concept, because when the king is absent, that's when the judge has the authority to decide. Well, old England, you went to the king, he was busy, he sent you over to the chancellor. He's not going to go there himself, he's got too much work to do. So, and the chancellor's too busy, he sends you to the sub-chancellor, okay? But basically, when the king's not there, you're supposed to be his mirror. In other words, you should decide exactly what he decides. Otherwise, you get reversed on appeal when the king says, nope, you were wrong. Okay? So, this is important because when you're in your sovereign capacity and you're issuing a writ of error, kicking out the judge's decision, you know you have a right because you wouldn't have done that yourself. Okay? Whatever the judge did. Okay? This is really a great case. Talking about this is the Jicarilla Apache tribe. Okay? Now, what happened was that the tribe went into a contract with a company. They were going to mine minerals off of tribal land. Well, after they got it all set up, the machinery's installed and so forth, the tribal council decided to apply an extraction tax on the minerals that got mined. Well, the company didn't like that. And he said, wait a minute, all you're doing is grabbing more of a bigger share of the cost here, or the profit. And it ended up that the tribe was sovereign and it could change the laws. Okay? So that's what they're saying here. It is one thing to find that the tribe has agreed to sell the right to use the land and take valuable minerals from it, and quite another to find that the tribe has abandoned its sovereign powers simply because it has not expressly reserved them through a contract. Who's the sovereign in your case? Okay? Assuming you're the plaintiff or counter plaintiff. So, if you're the sovereign, then that expands your powers. So it says here, to presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserves the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head. Once a sovereign, always a sovereign. Sure, you can go into contracts. So be careful with that one, because if it's a reasonable contract, you just don't want to be arbitrary and, you know.
If that contract had stated that the tribe could not impose a tax or something to that effect, would that have changed that, do you think?
Well, no, they came up with this taxing idea after the contract was made, after all the materials were being pulled out of the land and so on.
But I mean, if they had said in the contract that a tax cannot be imposed,
I don't think that's a reasonable clause. I don't think they would negotiate that. You know, unless they were desperate. No, they're not going to give up their sovereignty. Sovereignty's always there. So, but that's an important concept, because what this case is actually saying is you can be a citizen for some purposes and not a citizen for other purposes, and the choice is yours as so long as you have your sovereign rights. I mean, that's the implication here. It didn't come out flat out and say it, but that's really, that's your right. Here's another good one. The United States shall guarantee to every state in this union a republican form of government. Now, we discussed what a republican form of government was. Okay? So, it's guaranteed by the federal government. So, if all else fails, you can go, you're entitled to certain processes on the state level, but if the state starts wholesale denying your papers and not letting you even file, well, that's not how a republic functions. So, the United States guarantees it. That, to me, I interpret that to mean, hey, I can take this case over to federal court now. Okay? What's the reason I'm suing? Because I need the guarantee of the United States to force the state to act like a republic instead of acting like a democracy. See? This one argues against the state being sovereign. The words sovereign state are Kabbalistic words. I never really understood that. I should look that up. Not understood by the disciple of liberty, who has been instructed in our constitutional schools, which we don't have anymore, constitutional schools. It is our appropriate phrase when applied to absolute despotism. So, you have a despotic state, that's a sovereign state. But it goes on to say, the idea of sovereign power in the government of a republic is incompatible with the existence and foundations of civil liberty and the rights of property. That's a great case too. Because when they're trying to be dictatorial. How about the beauty police? You know, people come and say you can't paint your house a certain color because it's incompatible with the rest. Well, who's to tell you? So, anyway, that's the law of the case. But this is what the really purpose of me talking here is, to show you that here is the generic format. This is how you put all your papers together, the ones you're creating for yourself. And then, toward the end, this is actually an order, but in any case, we have here, it's signed by the court. Okay? And it doesn't matter whether it's the left side or the right side in common law. The king does what he wants, not what they want. Okay? So, seal of the court. Shall we take another break? Looks like it looks like the common law has spoken. So let's do that. Let's take a break. How long is this break going to be? It's almost 6 o'clock now, right? No, 4.
No, it's 5:55, yeah.
Yeah, almost 6.
Anybody have any votes? 10-minute break or 15, maybe?
15. I'll go for 15.
Or at this point, it's 6:15. Whatever. What do you think?
You want to make it 6:15?
Yeah.
Close enough?